Okay, so I say welcome to our Autumn 2023 Data Protection Update webinar. For those of you who don't know me, my name is Martin Sloan. I'm one of the partners in the Commercial Services team at Brodie's. I will be joined today by Grant Campbell, another one of our partners, and Rachel Lawson, who is an associate in the team. We have, I think, 350 sign-ups for this webinar, which I think is a record, and we've been doing this for a number of years now. So whether you're watching live or if you're going to catch up on this recording over Christmas with a mince pie and a glass of something festive, then thank you very much for joining us. We really do appreciate it, and it's great to see so many of you coming back again and again for this. Today we will be kicking off with Grant talking about international transfers. I will apologise in advance for Grant's voice. It is a bit tusky. He's asked me to pass that on. So do bear with us on that. He'll then pass to me, and I'm going to talk a bit about data protection in the workplace, looking at a few bits of guidance that have come out over the last sort of 5 or 6 months since we last got together, which is relevant to the use of employee information. And I'm then going to hand over to Rachel, who is going to talk about some other developments, including what's happening with cookies, some new guidance in the health and social care sector, the Online Safety Act, and some other bits and pieces. And we will, if we have time, try and pick up with some questions at the end. But say if we don't get to those, and we will try and follow up afterwards. So on that, Grant, can I hand over to you, and you'll take us through international transfers.
Thank you, Martin. Yeah, I will. Hopefully my voice will hold up for the next 10 or 12 minutes or so as I go through this section. So thank you very much, and do bear with me if I have to take a sip of water as I go. So this is the international update section, which is becoming a regular feature of these updates. For those of you who heard me speak in May, I talked a bit about the preparatory groundwork that was being laid in the US in terms of an agreement in principle for a new successor framework to Privacy Shield. And at the time, I said the intention was that that new framework would be in place in Q1 2023. And quite unusually for these predictions, because they often go awry, it proved to be correct. The European Commission published an adequacy decision in July to the effect that the US was ensuring an adequate level of protection for personal data transferred to US companies participating in a new EU-US data privacy framework. That decision, which runs to 136 pages, albeit with a lot of annexes at the back, based on effectively 3 core pillars, I think. There are data privacy framework principles issued by the Department of Commerce. There is an executive order, which I did mention in May, that was issued by President Biden, putting curbs on US signals intelligence activity, and signals, the US term for electronic surveillance. And the Attorney General, the US Attorney General, creating regulations to create a new data protection review court. And I'll look at these 3 pillars in a little bit more detail on the next slide. But the aim really is to introduce new safeguards. There are 3. One is the curb on signal intelligence activity, so it needs to be necessary and proportionate, and in pursuance of defined national security objectives. So national intelligence agencies shouldn't just be doing what they want to do. Secondly, a new redress mechanism for EU citizens. And then finally, reassurances from various US government departments, and there are various letters, appended to the back of the decision, reassuring the Commission that the departments will do what is necessary to actually implement the framework by putting in place policies and procedures, etc. So these are the kind of safeguards that are being put in place. On the next slide, I've kind of broken those safeguard measures down into the kind of 3 pillars. So you'll see on the left-hand side, there are the data privacy framework principles. There are 7 core ones and 16 supplemental ones. The 7 core ones will be familiar to data protection lawyers. There's slightly different terminology: notice, transparency, choice, so giving people choice, either opt out or opt in, accountability for onward transfers, security, data integrity and purpose, access to data, and finally, recourse, enforcement and liability. And there's some quite detailed provisions under each of these principles that are set out actually in the back of the Commission's judgment. And those core principles are supplemented by 16 supplementary ones, which support and amplify the core ones, but they have specific rules in areas around things like sensitive information, HR-related data, and in areas like pharmaceutical and medicinal products. So it's quite a corpus, it's quite a substantial chunk of work that is in there. The second pillar is the order from President Biden, which goes back to October 2022, which introduced safeguards on electronic surveillance activity under FISA and the previous executive order 12333. And this is all about the fact that non-EU and non-US citizens didn't have the same protections that US citizens did. And this is all about trying to redress that balance a bit. And what this introduces and requires is that national intelligence agencies introduce necessity and proportionality in relation to their intelligence priorities. And this is accompanied by a number of measures that are intended to give greater oversight of intelligence agency activity, and then redress through a complaints process, which neatly brings us on to the third element in this, which is the Data Protection Review Court. And this is dealing with again, just to reiterate, this is dealing with national intelligence activities. Ultimately, so firstly, you can make a complaint to the Civil Liberties Protection Officer in the Director of National Intelligence, but those decisions themselves can be reviewed by the Data Protection Review Court. And I think quite a lot of store was placed on the fact that the court is actually a court, so it is a court with independent judges. There are 3 judges will sit, but actually there's a panel of 8 have been created. You can find out who they are. They are publicly named. There are biogs for each of them. They tend to come from a background that is a mix of national security, but also positions in kind of preeminent US law firms. So the idea there is really to give people confidence that these are not just yes men for the government. They are actually independent judges, and these decisions are final and binding. But they also stress that aside from the courts, there is also redress through the US courts generally. So these are kind of the 3 pillars that the privacy framework relies on, and the European Commission's decision went to great lengths to kind of explain all these things and how they actually worked, and how they in the Commission's view provide appropriate safeguards for data being transferred to the US. I've gone to the next slide, please. So the data privacy framework sets up a scheme for organizations in the US to self-certify that they comply with these principles. So in some senses, that's similar to what was Safe Harbor and indeed what was Privacy Shield. Participants in the privacy framework appear on a data privacy framework list. They have to self-certify to the US Department of Commerce's International Trade Administration, and they will have to annually renew by self-certification, and they have to provide an independent recourse mechanism. So anybody, EU data subjects who are unhappy, can actually go to that or go to an independent organization to try and get redress for what they believe has happened. There are mechanisms that go beyond that. So national data protection authorities in the EU can pick up complaints and take those forward. These can ultimately end up at the Federal Trade Commission, responsible for enforcement. And finally, there is final binding arbitration with the EU and US DPF panel. So there is more than that. But anyone who is wanting to be accredited needs to pick an independent recourse mechanism, either in the US or the EU. I would expect US companies are largely going to look to US recourse mechanisms, but they can pick ones in the EU. The point about this is that if you're transferring data to the United States to a company that is within that framework, then you can do that without having to put in place additional data protection safeguards. I'll talk a little bit about the practical measures a little bit later, but because there is an adequacy decision in place, transfers to those companies within the framework, provided they are still in the framework, are deemed for all intents and purposes to be transfers in many ways as if they're within the EU, because these companies are deemed by EU law to adequately protect data. The framework is going to be reviewed in a year's time. So from July and summer next year, they'll review it to make sure it's working as it should do. And then there will be reviews every 4 years. Next slide, please. I think in terms of why this is different from Privacy Shield, I think I've put up a number of things there. I think the new Data Protection Review Court is new, and it is substantially beefed up on what was under Privacy Shield, because it goes beyond the ombudsman that was within the the Department of State, the US Department of State. So an independent review court, I think that does make a difference. The other thing that I think does make a difference, and certainly the EU are placing a lot of store by, is that it's an executive order of the president rather than a presidential policy directive. So again, they're saying that is much beefed up on what was previously there before. And I think the certification process is more rigorous than it was under Privacy Shield. Next slide, please. I think there's a wider piece to this. So I've been talking about transfers of data to organizations that are within the data privacy framework. But a lot of the measures that have been put in place by the US will actually have a wider bearing on transfers to the US generally. And the European Commission were at pains to stress that when they announced the data privacy framework. And I've put the quote on the slide. So what the Commission said was all the safeguards that have been put in place by the US in the areas of national security apply to all data transfers under the GDPR to companies in the US. So not just to those within the data privacy framework. Those safeguards, therefore, also facilitate the use of other tools, such as standard contractual clauses and binding corporate rules. So the change in the US landscape that's been ushered in by these measures, in the Commission's view, has an impact on actually the use of the other tools that are open to controllers to transfer data to the US. So, and that caused the European Data Protection Board to update its guidance, saying that actually looking at all of the Article 46 transfer mechanisms, they viewed the fact that these changes have been brought in place as being something that would be significant. Next slide, please. You may be thinking, well, this is all very good. This only deals with the EU and the US, but the UK was fairly quick to look at the EU-US data privacy framework and then issue its own adequacy finding based on that framework. So it's piggybacked on that privacy framework. And in October this year, these UK regulations came in force, so effectively piggybacking on the EU adequacy decision. The UK wants it to be known as a data bridge rather than an extension to the EU privacy framework, and you can understand why. For political reasons, that suits that narrative. What the UK has done, and I think the reason the UK has done this, is by piggybacking on the EU framework, it also helps kind of cement or it helps be consistent with the adequacy decision that the UK has from the EU. So it's the same US supervisory authorities as police the EU data privacy framework, and the same access to individuals for redress mechanisms. So by aligning up with the EU's adequacy decision, I think it helps cement the place of the UK's adequacy decision with the EU. Next slide, please. So I think where does this leave us? Well, I mean, I think clearly, if you're dealing with other organizations, suppliers, and you're looking at transfer data to them, is the supplier in the data privacy framework is clearly a key decision. But I think ultimately, and that does secure adequacy, but I think, ultimately when you're looking at transfer data to any jurisdiction, ultimately you want to conduct proper due diligence. Ultimately, you may be responsible for what happens with the data. A number of questions in no particular order for you to still to be thinking about. If you're transferring data to suppliers, even within the data privacy framework, where are they transferring their data to? Does that align with what you have told your data subjects? Potentially look to position your suppliers as exporters of data rather than you as your organization. If you are not using the data, if your supplier is not within the data privacy framework in the US, what transfer tools do you need to put in place? Even if you are relying on the data privacy framework, it may be that you take the view that you want to have a belt and braces approach, and maybe also use other transfer tools alongside that. Have you carried out appropriate risk assessments? Making sure that your privacy notices are up to date with what you're doing in the US as well. And are any other additional safeguards required? Unlikely to be where you're using data privacy framework, but if you're using other transfer tools. And just finally, last slide, please. It's actually the penultimate slide. Just wanted to talk transfers. But in a more general context, there is a lot of activity in the US. As I mentioned, the proliferation data protection regimes when I spoke in May. This is just a quick ready reckoner of activity in state law in the United States. So with privacy laws, and you can see there, state laws in Connecticut, Colorado, Utah, Texas, Florida, Oregon, Montana, Iowa, Tennessee, Indiana. They all, I think, draw to a certain extent from Californian data protection law, but also GDPR. I think one of the things, though, to bear in mind is whilst they at first blush may be similar, they're not harmonized, and therefore there are differences between different states. So if you are looking at data being exported into these states, then you have to recognize that the state law is not harmonized, and there will be differences, particularly in areas about what is or is not sensitive data and what rules apply to that. And then just finally looking beyond the US, other key territories, Indonesia is going to be bringing its data protection laws into force for enforcement in 2024. I think significant is India has now actually got its own national data protection law. The date in which it comes into force has not yet been announced, and there are a whole load of rules. So it's framework legislation with a whole lot of detailed rules and a whole load of areas to be introduced. So actually what shape that takes, I think will only become clearer in time. But if you are outsourcing data to, and particularly IT outsourcing to India, I think being aware that India now has or is going to have a full-blown data protection regime will be important. So we'll keep you up to date on that. This will be a regular feature of our talks. So I hope that was helpful, and I will now hand on. Thank you.
Thanks, Grant. So I'm going to talk about in this section about data protection in the workplace and various new bits of guidance in either final form or draft form that came out from the Information Commissioner in the last few months. So the first one is around employee monitoring. So this guidance has not been updated since GDPR came in, and obviously in terms of the technology that's out there that enables organizations to monitor what their employees are doing, the world has moved on quite a lot in the last 5 years or so, 5 and a bit years. And when we're talking about monitoring, we are talking about quite a wide range of things. So I think when the original guidance came out from the ICO, monitoring was really focused on maybe use of CCTV, maybe monitoring emails and things like that. But we've now moved on, and there are so many other ways you can monitor what people are doing. So monitoring calls, messages, keystrokes, use of webcams, body-worn video cameras, audio recordings, vehicle tracking, activity tracking, things that detect when people are sitting at desks or when they move away from the desk. All of these sorts of systems are out there. And one of the things that I think organizations need to be aware of is that vendors will sell these systems, but they may not necessarily be lawful, or they may not necessarily be lawful in terms of how they are being marketed. So the fact that someone is selling you a monitoring system that sounds great doesn't necessarily mean that you can just plug it in and use it without needing to think about the data protection law issues, because actually the majority of those obligations sit on the employer, the organization that's buying it, rather than the service provider. So it's always good just to, as I look at what you're being offered and whether it actually is something you can use. So we've got some new guidance from the ICO on this. It is following what seems to be the ICO's new approach for guidance, which is a sort of must, should, could approach around things that you must do, things that they want you to do, and then suggestions. And I think some of the other guidance that Rachel will talk about follows that approach as well. But the ICO recognises that there are lots of different reasons that you may need to monitor what people are doing. So that might be around quality, the quantity of work that people are doing to comply with health and safety, which is quite an important one. There may be some regulatory requirements. There may be some issues around data security. And again, we're seeing this as a trend to measure performance and well-being and things like that as well. So on the back of that, we have some new guidance which will help organizations to assess what they're doing in relation to this. And a lot of this will be familiar to those of you who work regularly in data protection law. There's nothing really radically new here, but it is just a helpful reminder. And the first one here is that any monitoring you carry out has to be fair and lawful. So you've got to be able to identify a legal basis for that, whether that's just for personal data or for special category data. And you've also got to think about whether what you're doing is fair, does it meet the proportionality requirements as well. And the point here is that if you're carrying out excessive monitoring, then that's going to intrude into workers' private lives. That may have well-being issues and privacy issues, and it will likely be unlawful as well. So it's not a binary thing as do we monitor or do we not? It's also about actually how do we do that. So looking at how that monitoring works, what you're doing and how you use it is really important. You've got to sort of look at your own interest as an organisation. And compare those against the rights and freedoms of individuals under data protection law and also human rights law as well. What would they reasonably expect you to do? Are you going beyond that? And how's that working? I think the ICO published a survey when it announced this guidance that suggested that a number of employees were actually worried about excessive monitoring and use of systems that they feel goes too far. So you've got to be clear about what your legitimate purpose is for that monitoring and why you're doing it, but you also need to think about that proportionality principle is find the least intrusive way of doing that. And on the next slide, we've got a couple of examples from the guidance which kind of bring that to light. So first one here is an employer who has remote workers who seem not to actually be doing the work that they suggest they're doing in their timesheets. And so it rolls out some wants to roll out device monitoring to enable management to log into webcam images and check if people are actually doing the work. And we've actually looked at this a number of years ago before the pandemic in relation to a client that was looking to roll out remote working, and there was a suggestion around using a system like this. And what the ICO says here is that that's likely to infringe data protection law because it's disproportionate. You don't need to have webcams that are always on that anyone can always go in and view in order to actually check when people are starting and finishing work. That is quite intrusive. You'll be able to see into their own home. Compared to other means of doing that, you could simply do it by working out when they log into their system and looking at their use of the IT system. You don't need to actually have a video camera that's constantly watching them. So that's one example. The other example that's given here is around a logistics company, and they have obligations under health and safety laws to actually monitor how much time people are driving, speed, distance that they are driving, and the rules on working hours. So in that case, actually, they do have a lawful basis for this, and they structure this and they do this monitoring in a way that doesn't go beyond that. And so, for example, if you're doing fleet monitoring and people can use a company-provided vehicle at home, you might want to switch off the monitoring so that when they're using that vehicle for their personal purposes, you're not monitoring where they are. So a couple of examples there that maybe bring that to life. So just to round off on employee monitoring, how do you approach this? Well, you want to do a DPI on all of this, but really you're looking at what it is you're wanting to achieve. How can you do that? What sort of monitoring do you want to do? What's the technology you want to do? Is this the right thing to do? Is this the proportionate way to do that? Find your legal basis. If you're doing any automated decision making, so that's decision making that has a legal effect or a similarly significant effect that is like that, then you need to bear in mind your Article 22 obligations under UK GDPR in terms of ensuring that the decision making you're making is valid under that, and that you give data subjects their rights. You might also want to think about other obligations around human rights and equality as well, because again, this can come into the use of employee monitoring. You want to make sure you have the right policies and procedures in place, so safeguards to ensure it's used properly, retention periods, who can have access to that information, and so it is only being used for the right purpose. And then number 8 is really important, because with all of this, you need to be transparent with employees. So communicate with your workforce, update your privacy notice, tell them what it is you're doing, so that they can understand that, and there's not a suspicion that you're using it for purposes beyond that which you're intending, or carrying out more monitoring than is necessary. And the more that you can record all of this in your decision making will help you to demonstrate accountability if someone challenges you on your approach. And the final point there, just around ongoing review, again, we see this, that you do an exercise at one point, and then there's some form of scope creep or function creep where additional functionality is switched on once a system has been commissioned. So it's really good just to get into the habit of regularly reviewing how these systems are being used, and if the vendor adds some more functionality, it's not switched on without thinking about the data protection consequences of that. The next thing I'm going to talk about is on subject access requests. So we've got some new employer-focused Q&A from the ICO intended to help organisations dealing with DSARs from employees. So a couple of useful bits in here. The reminder that you can clarify the scope of a DSAR, but you should only be doing that where you have some reasonable uncertainty. You shouldn't use it as a delaying tactic. If you've got large amounts of data being processed and it's an all information request, then you are entitled to go back and ask someone to try and clarify what they're looking for, so that you can find that. And that goes back to the ICO's expectation that you carry out reasonable and proportionate searches. So the ICO gives an example of an employee who's worked somewhere for 20 years versus someone who is a shorter served colleague, and saying with the former, clearly there'd be large amounts of data and you'd be entitled to go and try and clarify what the scope of that is. Unfortunately, we don't really know what a shorter served employee is, and I'm sure certainly that's my question. Well, at what point do you distinguish between that? Is that 3 months? Is that a year? We don't really know, but it is helpful, I think, to make that distinction in terms of the volume of data you might have. There's also some practical guidance around how you deal with third-party personal data. So the examples given around, say, pay increases, where you have information on comparators and someone submits a DSAR. If you're doing that, then make sure that the information you provide in other people is anonymized, so that they can't see or identify who those other people are. It's not just a case taking names out, potentially roles as well. With CCTV recordings, the ICO makes the point that any CCTV system you use these days should be capable of redacting or blurring footage, and therefore they expect you to do that and not just withhold footage simply because you can't do that, or that might be too difficult. So helpful to understand the expectations on that. And then the other one they mentioned around this is on witness statements. And again, we see this quite a lot when we work with our colleagues in employment on DSARs, where there has been ambiguity or uncertainty as to the expectations given to witnesses in a grievance around how their witness statement will be used. So if you have given confidentiality assurances around the use of their statement, you may be entitled to not provide that, and may be very difficult to do it in a redacted or anonymized format. But you just need to be clear on actually what you're processing that, bearing in mind that any witness statement you get, you would want to be able to use in a tribunal or as the process goes on. There's guidance on common exemptions, so things like the application of privilege, management forecasting, where, for example, you're making decisions about whether you restructure the business or make redundancies, and also around negotiations with individuals as well. So a DSAR in the midst of a settlement discussion, you would be entitled to withhold information that might prejudice those negotiations. Some guidance on references, and just making the point you can decline that if they are given in confidence. So again, being clear on your approach in that. And we also have some guidance on manifestly unfounded and excessive requests, which just follows the guidance published previously by the ICO on these principles. And the last point on settlement agreements. So again, we've seen this question come up a few times. The ICO emphasizes that you can't require someone to waive their rights under data protection, or you can't waive your rights to make a subject access request. It is a statutory right you have, so it's not something that can be waived. And therefore, if you write that into a settlement agreement, then that's not going to be enforceable. However, there are things you can do to make it easier to then reject a request on the basis that it's manifestly unfounded or excessive. So if you had entered into a settlement agreement with someone and they've waived all their claims under employment law, and you've given them information, then you may be able to write some things into that settlement agreement that make it harder for someone to make a request a month or so later when they've already gone through that settlement process. So there's some tricks in there. If you want to speak about that, get in touch, because we've dealt with that on a few DSARs and settlement agreements of late. And then the final section I'm going to talk about is just on biometric data. So the ICO has published in draft guidance on this. This doesn't just apply to employers, it applies generally, but we see this particularly in the workplace in terms of biometric systems. So the first point that's just to bear in mind is that using biometric data for identification is special category data, and actually that may change in the new data protection bill actually to be widened to be any biometric data, but at the moment it's just where it's used for identification. But that then means that if you are looking to use, say, facial recognition or fingerprint scanners for access controls to buildings or things like that, then that will require a special category data condition in order for that to be valid. You can't just rely upon legitimate interests. And I think the point here, and it's a bit like what I was saying with some of the other stuff, is that this sort of technology is now so commonplace that people, I think, sometimes forget about the data protection issues, and the vendor doesn't really flag them to you. And these systems are possibly deployed in places where actually there is no legal basis beyond explicit consent. So really important to carry out a data protection impact assessment if you're looking to use biometric technology. Who is the controller? Is it you? Is it the service provider? What information you're collecting and why? Have you got a legal basis? And the ICO is quite clear in this, that if you don't have a legal basis for using special category data, then you will need to rely upon explicit consent. And that consent needs to be freely given, which then means you need to provide an alternative for anyone who doesn't provide their consent. So that can be quite tricky. If you need to really work through the process, what's your legal basis and how do you deal with that if you're relying upon consent. Within your DPI, you also want to look at risk mitigations as well for ensuring that the system doesn't give rise to unnecessary risk. So vendor diligence, really important here to actually ask questions to the supplier. How does the system work? How can it be configured? Because quite often the out-of-the-box approach just doesn't really quite work. It collects too much data, it retains it for too long, and you need to really test what your supplier is doing on that. The final point I just want to make on this is, and this is draft guidance, so we'll see what comes in the final version, but the one thing that is really missing from this guidance for me is there's nothing in here on how you actually assess proportionality and necessity. And that, I think, is particularly relevant to workplace technology. So you may say, well, actually, we want to use facial recognition for access to bits of our building because from a health and safety perspective, we think that is a necessary thing to do. And say, I don't know, you work in a food production facility, actually from a hygiene perspective, it's much better than someone typing in on a keypad to do it by facial recognition. There may be a health and safety reason for doing this, but what we don't know from the ICO is their view as to whether that is sufficient and whether on the necessity point, is that okay? Or would the ICO say actually there's a less intrusive way of doing this? So that's the one thing I'd like to see in the final version of the guidance. We will keep you posted on whether anything comes of that. So that, I think, is my section. Rachel will take you through some other developments.
Thank you, Martin. Yeah, I will now go on to speak about some other developments that have taken place since our last update. So firstly, looking at cookies, the ICO has recently taken action to warn businesses that they will face enforcement action if they don't make changes to comply with PECR and the UK GDPR. At the moment, we understand that the ICO has targeted businesses that have made it more difficult for users to reject cookies while visiting their websites when compared with the user's ability to accept them. The businesses that the ICO is written to aren't named just now, but we do expect at least some to be named in January if they haven't taken the steps the ICO has asked them to address appliance in due course. As part of this, the CMA and ICO have also published a joint paper on harmful design in digital markets, detailing their joint concerns about website design practices which negatively affect consumers and their right to control how their data is being used. This focuses on the key themes of putting the user at the heart of design choices, using design to empower user choice and control, and testing and trialing design choices. In short, the ICO considers it an infringement of data protection law if the website design makes it harder for users to choose more privacy-friendly options and influence consumers to make decisions that don't reflect their real privacy preferences. A particular point to flag is that this now confirms that a reject all banner is mandatory, removing any doubt on that. And another point to quickly mention is that, and something that we actually come across quite a lot in practice, is the confirmation that although many website providers use third-party contractors to help design their websites, it's ultimately the website provider's responsibility to ensure that their website complies with all relevant cookie rules. So just on that, a point around supplier management and active engagement with any website provider that you do use if you do outsource that. So moving on to health and social care. And this is running until the 7th of January. The ICO is now consulting on new draft guidance. The aim of the new guidance is to provide a reference framework for health and social care services providers on their transparency obligations in relation to the use of personal data. So in terms of the policy background to this, the ICO is now taking an active interest in organisations making sure that individuals are actually aware of how their information is used. And the key point there is that this may actually require organisations to go above and beyond providing the usual privacy information that you would supply as part of the right to be informed under Article 15. Essentially, the ICO is seeing this as important because of the key role that specifically transparency plays in influencing increased trust and positive outcomes for users and the public more generally within health and social care settings, particularly in light of the increased and widespread use of technology in all aspects of health and social care, as well as in relation to data sharing between different organisations, which can arise at all different stages of an individual's interaction with health and social care organisations, essentially through from frontline delivery of patient care through to research activities. So in the same way as with other recent guidance, and as Martin set out earlier, in relation to the employee monitoring guidance, this guidance also follows the must, could and should format. So on the slide, there are some key takeaways in relation to each category. So just running through a couple of them. On the must side, organisations must make sure they have a clear reason for using information, and organisations should be open and honest about their intentions and operate transparently. On the should side, this is quite interesting. Organisations, as well as actually providing the information, should be thinking about how they can actually communicate transparency information efficiently. So it's asking organisations to think about what would be the most effective ways of communicating with your particular audience, and how could you deal with complexity and avoid information overload. Then on the key side, the could side, sorry, when providing transparency information, the ICO is suggesting that organisations could consider a few different aspects around providing information that goes beyond what is in Article 15, as we've just mentioned. So, for example, giving information around how decisions have been made concerning the use of personal data, and maybe also going so far as to give some information around the accountability framework, such as meeting minutes and policies and information governance, which have been used to influence actually how information has been decided to be used. So moving on to the Online Safety Act, this finally received royal assent in October, and we will now expect its substantive provisions to start to come into force as and when the Secretary of State and Ofcom make relevant regulations and issue guidance. At a basic level, the Act is concerned with user-to-user services and search services. Ofcom, who will be responsible for its regulation, currently expects around 100,000 businesses to be initially caught by the Act, and this will cover sectors including social media, gaming, and online dating. In terms of the policy rationale behind this, it is intended to protect children online while preserving free speech. And in terms of timescales and priorities, we understand that Ofcom will first focus on illegal harms, then moving on to specific child safety duties before looking at certain categorised services. So upon that context, what kinds of activities will specifically be regulated by Ofcom in the new Act? Well, on the user-to-user side, this means internet-based services that allow content generated directly on the service or uploaded to or shared on the service by one user to be encountered by another user or users. So examples include video sharing, messaging, marketplaces, review services, file sharing services, discussion forums. Then on the search services side, this is really around internet search engines and any site that they could be also built into. So in terms of the key features of the Act, generally compliance involves risk assessments, various mitigation measures, and some other specific obligations. But the extent of those obligations do depend on the type of company, with the most onerous obligations being put on organisations that do have children accessing or likely to access their site, and they'll be expected to do things like keeping records of compliance with their obligations specifically actually under this Act, and also publishing them as well. Then otherwise, all providers of regulated services will have to comply with certain core obligations, including conducting risk assessments, setting up policies, and undertaking mitigation measures as well. On the regulation side, moving on to the next slide. Sorry, if we go back a second. Sorry, so on the regulation side, Ofcom will be the main regulator here. It firstly has a responsibility in bringing the Act into effect and then also supervising compliance as the regulator. So on enforcement, if we cover that in more detail, it's quite interesting. So Ofcom will have powers to impose fines of up to 18 million or up to 10% of annual worldwide revenue, whichever is greater. And there's also an interesting point there around senior managers could be held criminally liable for certain infringements of the legislation. So for example, if Ofcom issues an information notice to a regulated business, it may require that entity to name a senior manager, and they would then have to ensure compliance with the requirements of that notice. If they didn't, that individual could be held criminally liable if the business didn't comply with the notice. So that's just something to note there. Moving on to reform, so the the DPDI bill is, well, we're expecting it to finally become an Act within 2024. However, very recently, just last month, a new amendment process was looked at in Parliament, so these are now being considered, but there was around 124 pages worth of amendments from different members of Parliament on all sides of the House. So a couple of them are noted on the slide there. As I say, what will happen now is they will now be considered by the House of Commons, and we will do an update if there is anything that goes through to the actual bill. But as I say, we do expect that to become an Act over the course of 2024 at some stage. So otherwise on horizon scanning, what else can we expect to look, or what should we be looking out for over the course of 2024. So there's a few recent ICO consultations which have recently closed, and so we will look out for any guidance or any other codes of practice that come out from the ICO based on that. As I mentioned, the DPDI bill will continue through Parliament. A new act will come into force on December the 31st, which will clarify what a fundamental right or a fundamental freedom means under the UK GDPR. So, for example, when undertaking legitimate interest assessments, the Act essentially will clarify that controllers should be considering convention human rights under the Human Rights Act when undertaking those assessments. On standard contractual clauses, it's just a reminder that if you're on any of the old EU SECs, you do have until 21st of March to move yourselves onto the new UK specific mechanism. So whether that's the new EU SECs plus the UK addendum or the IDTA, but the 21st of March is the deadline for moving on to those. And will 2024 see us see more misuse of private information claims overlapping with GDPR and Data Protection Act claims? You may have seen in the media that David Walliams has recently reached a settlement with Fremantle over leaked recordings taken from him during so-called downtime when filming Britain's Got Talent. We're starting to see more claims being made by individuals in relation to psychiatric injury flowing from personal data breaches, and so this is just an interesting interaction with other more general privacy rights, such as misuse of private information, so we may see more of that over the next year as well. That's all from me.
Thanks, Rachel. I'm conscious of time, but we've got a couple of questions which have come in, so if you can stay with us, then please do that, and we'll just go through them. Grant, they are largely all for you. International transfer is clearly something with lots of questions. To save your voice is one which I'll just answer, which is there's a question around whether remote access to data is a transfer. The answer to that is yes. So if you have someone remotely logging in from another part of the world, then yes, that is a transfer if it's from another organization. But if it's one of your own employees overseas, then no, it's not. The one I wanted to pass to you, Grant, is it's Mr. Schrems, who we talked about many times before. Do we think that Schrems 3 is coming? Does that mean it's too risky for organizations to actually use the new data bridge? Is there any point until it's gone through the courts? And is it possible it could be struck down in the EU and not the UK? Could the UK courts decide not to do anything, but the EU court does?
So I think Max Schrems isn't impressed with the new data privacy framework. I think he described it as a copy of a failed privacy shield. As far as I'm aware, he's considering all of his options. I think a couple of areas where he's been particularly unhappy. I think firstly, he doesn't think the executive order, the presidential order, goes far enough. And I think also not particularly impressed with the Data Protection Review Court, given that a lot of its findings are likely to be classified. I think, though, the European Commission clearly have had Schrems 2 very much in mind when they have been sculpting this adequacy decision. And certainly the pronouncements, such as they have been from the Commission, have suggested that they feel pretty confident that if this actually did get to the European Court, they would hope that this would actually stand up. So I think that it's getting more difficult. I think as each iteration of this gets refined, it gets more difficult, I think, for a successful challenge. That doesn't mean to say it won't be successfully challenged, but I think it gets more and more difficult as they refine it and the standard of the safeguards that underpin it gets stronger. It gets more difficult, clearly, to attack it. I think probably, is it possible? So I think firstly, can you rely on it? Well, yes, subject to the fact that there will be a challenge. I think the challenge is inevitable. It will be, I think, a couple of years before that gets to a European Court decision. Should you use some other transfer tools, perhaps in a layering approach? Well, quite possibly that would be sensible. But I do think at the moment this has got some life in it for certainly the short to medium term. So I think organizations will use it, and we've seen a lot of organizations in the US interested in using it. including a number of clients. Is it likely that this could get struck down in the EU and not in the UK? Yes, I think it is possible. I think if it were struck down in the EU but not in the UK, that may have implications for the UK adequacy decision from the EU. But the fact that it's been aligned with the EU privacy framework, so the UK data bridge, I think it makes it more difficult to see a scenario where it would survive in the UK and not in the EU. So it is possible, but I think that would have wider implications for the adequacy decision that we've got from the EU. I think there was also a question about whether or not there would ever be a stage where we could see transfers to the US taking place without having to put in place any transfer tools. I think that's difficult to see on the horizon. I think it requires a political decision effectively to enact a federal data protection law of a relevant standard that would meet EU adequacy regulations or an adequacy decision. The US's approach has always been sectoral. Now we're seeing a whole load of state laws. I think it's difficult to see, certainly short term, anything in the US that's going to satisfy an adequacy decision on a kind of broad brush basis. Great,
thank you very much. So that's all we have time for today. Thank you very much for joining. We will be doing this as ever in the spring, so do watch out for the invites to that session, and we will of course be doing updates now and then on the website on things that develop over the coming months. So thank you again for joining. Thank you to Grant, thank you to Rachel. When you leave today's webinar, you'll be asked to fill in a short survey. Please do, if you can, take the 30 seconds to do that. We really value the feedback, both on this session, but also on what else you would like us to cover. So if you can spare the time to do that, we would be really grateful. And on that note, is it too early to say Merry Christmas? No, I'll go for it. Have a great Christmas, and we will see you all in the new year. Thank you.
Thank you.
Thank you.